Okay, well, good morning and almost good afternoon. I see people are filtering in, and we're going to let this load up. I know we have well over 130 people. I think we had 350 people registered for today for our meeting and our presentation to follow afterwards. So as everybody pops up in off the screen, that's great. I encourage you to turn your cameras on. I would love to be able to see your face and for all of your fellow members of the elder law section to be able to see you and say hello. I believe that if you want to ask a question, you can unmute yourself, and that'll allow you to ask a question. But we do have a number of people in here, so let's be mindful of that. It's I don't know. And Lane, I guess you're monitoring the chat, and I'm seeing some people asking if they can join in at this point. I don't know what the availability of that is. But with that, let me just dive in. My name is Paul Hamilton with Hamilton Trust Estate and Elder Law, located in Valdosta, Georgia, and I am your section chair for the Elder Law section of the State Bar of Georgia. And I believe we opened this up. I don't know if we opened it up to other sections or whatnot, but I welcome you all for coming here today so we can have a brief meeting to kind of talk about the section, and then we can go into this presentation we have about what you and your parents should know, and I would say everybody should know about estate planning and elder law. Of course, I introduced myself as your chair. We also have Josh Nelson, who is our vice chair, and Josh is not. He's tied up with a matter, and he said he would try to jump on if he's able to, but right now he's tied up. But we do have Bill Rhodes on here. Bill waving his hand there, and Bill is our secretary treasurer for the section. And he's located in Gainesville, Georgia. And of course, we kind of rebooted the section last year, and were able to start doing stuff again. I think that we had kind of gone defunct, if you will, for a number of years, to the point that they were kind of looking at closing the section down because we weren't putting on and doing events and really doing anything with the section. So a call went out, and a few of us decided to jump in there and help reboot it. And throughout last year, let me pull up my page over here on the other screen. I want to just kind of give an overview of the things that we did last year, and then talk about some things that we're going to do in the coming year. So last September, we put together a lunch and learn at the State Bar that really focused. We talked about the transfer on death deeds, and I know the real estate section has dove into this as well. And now that law is in effect, I think it went into effect last July 1. And there's a lot of issues in elder law with using transfer on death deeds. That I know it's a tool. It's another tool in our toolkit, but that piece of legislation has some things that they're working on, the tweaks in trying to make it better. I don't know if anybody else on here has used those as a estate planning tool yet, but there are issues with it that need to be cleared up. So that's something that we did, and that was a very well attended event. And we had a lot of people. I think our friends in fiduciary law joined us, real estate law joined us. We had a full room at the State Bar, and then we had a great gathering afterwards, a social event. And then in the fall, later on in the fall, we did a Top Golf event. We didn't have great participation at that, and we spent a good lick of money, and actually have a credit to use for that Top Golf event to do another one. We're going to kind of open it up and see if there's interest in doing that in the fall. And we also did a CLE this past summer at the annual bar meeting. I'm trying to remember where we were for the annual bar meeting. I think we were at Ponte Vedra. and we did a CLE, the same CLE that we're doing today. We did down there with a number of people. I think we had about 40, 50 people roughly that came to that event. And we also did a social hour afterwards. And there was one other event we did where we brought in think we brought in a financial planner, and we had an event. I believe it was in Savannah. I think it was the one of the storm weekends, and we did that in conjunction with a bar meeting. So, we're trying to put together things for our members that are helpful. I know that one of the requests that I heard a lot was a resource for us all to have, and I am pleased to share with you. Hopefully, if I can do this right, I put in the chat the name or the address to the Facebook group that we just had set up. So I recommend you go to that. If you search for it, it's a little tricky. So if you type in Georgia Elder Law section, it won't necessarily pull it up, but that link will get you where you can request to join, and we'll match that against the member roster that we have so that we can admit you to that group so we can share ideas and share information that is germane to elder law throughout Georgia, and give us a place to communicate and also provide resources that people are asking for in this regard. I wanted to get some feedback. One of the things that we talked about in our executive committee, and I want y'all to know that I talked about the events that we did last year, but your executive committee, which consists of myself and Josh Nelson and Bill Rhodes, and then Lane from the State Bar of Georgia is our section leader guru, and Mary Jane up there as well. They all support us, and we get together twice a month to talk about moving things forward and what are we going to be doing and what are we going to be tackling. But we rarely have a chance to hear from the entire body of our membership. So I want to give us an opportunity in just a minute. I'll talk about what we got on tap for February, and then I want to open it up and take any questions, suggestions, and that kind of stuff in the remaining few minutes of our business portion of the meeting before we do our presentation. So let me talk about February. Something we're trying to put together. It's basically a 6-hour, a 1-day kind of workshop, CLE, if you will, where we'll do a 3-hour session in the morning and a 3-hour session in the afternoon, probably starting at 9, going till noon, and then having lunch together as a section, and then doing another 3-hour session from 1 to 4, and focusing on basics of estate planning in the morning and more advanced subjects in the afternoon. So it'd be a 6-hour CLE that we would be able to do to provide information, and also just have some camaraderie and some networking to know, how helpful it is to know people in other parts of the state and what they do and who you can send people to, and plus just the general information that you would be able to get. And I'm looking at some of the things in the chat as well. So that's what we have on tap for hopefully sometime in February. We had a tentative date, but we're going to have to tweak that, I believe, because there wasn't availability at the state bar. With that, I would, Bill, do you have anything you want to add or say on here?
Yeah, if you don't mind for a second. Sure. One, thank you all for being here. This past year has kind of been my first foray into anything state bar related. All of us have just tried to kind of pick up a defunct section and run with it. To me, it's been great to talk to Paul, to talk to Josh. I just want to reiterate, I guess, that we really mean it when we want ideas. We're trying to figure this all out. We just rolled out that Facebook chat group. Bear with us if there's some hiccups. I expect there might be some hiccups, but we're working hard to make sure that there's a path for communication and questions among this group. one of the other things I also wanted to let y'all know that we've talked about internally as an executive group, but have not talked about with the larger group that Paul did not mention, is kind of a inundation of unauthorized practice of law in our field. And we have started bringing that up. I had dinner the other day with somebody who's on the unauthorized practice committee. But I see Facebook ads all the time. If you click on one, you're going to get 24 of them of financial advisors, insurance agents, annuity salesmen, whoever who are trying to practice in our field and practice in our world. I have no idea, candidly, if anything can be done about it or not. But that is something also that we are noticing, and we are trying to get the bar's attention on to see what happens. So.
Bill, thank you for bringing that up. I completely left that off my notes to touch on, and that's something that we have talked about in the in our exec meetings, and I'm sure you're all seeing it in your communities. I have a number of people, in the Valdosta area. They know that I'm kind of the guy that does Medicaid asset protection planning, and they saw something posted for a workshop that was being held at Valdosta State University talking about wills, trusts, and probate and how to protect your assets. And people are calling me saying, "Is this you doing this?" And I'm like, "No, but let me find out who it is." Well, it's an insurance salesman from Albany that came to Valdosta State College or Valdosta State University, and I actually sent my associate to the workshop or to the thing, and they were giving all kind of legal advice about trusts and everything. And so we have copious notes, and but how do we thread that needle, right? Because um, that do we make it a collaborative thing, like, hey, you're not giving good advice here, let us collaborate with you, or stop giving that advice. Stay in your lane, because like y'all, I work hand in hand with a lot of financial advisors and CPAs. So I don't want to create an adversarial relationship, but I also don't want the community at large to be given advice by people that aren't educated to do it. I don't give people advice on what stock to go buy because I'm not trained in it and I don't follow it on a day-to-day basis. So I would encourage you to please let us know if you're seeing that in your communities, where you're seeing people kind of getting out of their lane. It's a careful balance, I think, because we do want to provide access, particularly for lower income people, to basic wills and healthcare directives and financial powers of attorney. I know we want to provide that service for those people. I really think so. There's a distinction between providing that and getting into trust-based planning and more of the advanced stuff. So with that said, I would like to open it up either to the chat group, or if you would like to unmute yourself, if you have a question or suggestion about an activity, a particular training that you're interested in, and those types of things. So don't be shy.
Hey, Paul, let me add one more thing. We've got the weird advantage of having a defunct group where people have been paying membership dues for like 5 years and nobody's ever used them. And so what's kind of cool is we do have dollars to go get speakers. I mean, we've got resources and assets to go and do stuff, which is wonderful. We've talked to the state bar, and they candidly said spend the money. And so we're working on that. But when Paul's throwing out the what do y'all want, we really do have some resources behind it to try to accomplish things.
I'm glad you said that. Mary Jane, when we jumped on and kind of started things back up last year, she said, "Look, you've got money, spend it." So we have not been shy about that. We've spent money. We're hosting these cocktail hours, and those take resources to put on, but we've got the resources, and we have the resources to bring in some really good speakers, and to help compensate for travel costs and honorariums and such to bring people in. So please give us your feedback on that.
And we've been trying to schedule that slot right now. He's not cheap, but he's a tremendous speaker, as an example.
Yes, and hopefully we'll get that teed back up. So any suggestions for y'all or comments from y'all. 2 trainings I'd like to see. One, information about the new probate mediation requirements and FINRA arbitration. Oh, okay. That's very good. And who can speak on that? I'm unfamiliar about the new probate mediation requirements. Did that go into
Paul, I
effect?
can chime in just for a second, but I know there's more qualified people on this group than I am for this. But you now have to be a specialist in probate to do probate mediations. And so
Oh,
I
okay.
suspect that that's what's referring to. I think that would be a wonderful idea to get
It is.
somebody to, actually give an hour presentation or something like that, on the requirements, et cetera.
Does anybody know who has gone through that and who has been approved to handle those? Does anybody know of anybody in that respect? If you do, you can chime in or whatever on that. That's really good. And the other one was on FINRA arbitration.
Are you referring to just someone that's certified to mediate the probate matters?
Yeah.
It's got,
Yes, ma'am.
I am.
Oh, well, great. So, so maybe I don't know if you'd be willing to help us do a little blurb on that, a 30-minute to hour-long CLE. I don't know if it would. I don't know if that would take up that much time. But if so, now do you have to have practice probate law for a number of years in order to get this approved, or what's the?
No, basically you have to complete the probate mediation certification program,
Oh,
which
okay.
is somewhat similar to being a mediator, and you've got to do that as well.
Okay.
I've forgotten how long their training was, but and it goes through a lot of the basics of probate law.
Oh, okay.
Hey,
Well,
Ann, hi, how are you?
Good. Hey, Bill.
So I think and you also have to already have your standard mediation
Yes.
correct,
Yes.
and this is on top of that. Is that right?
Yes, that is correct.
Oh, good. That's great. When did that go into effect? Is it past year or two?
I think it went into effect July the 1st, but I'm not positive.
Okay. Well, that's news to me. I'm glad that someone brought it up. Who's familiar with the FINRA arbitration piece that Courtney brought up?
Well, hey, I'm Courtney, and I actually am a FINRA arbitrator,
Oh,
and
wonderful.
that's one of the reasons why I'd like to see more information on it. Is it's something that could be very, very helpful for Georgia practitioners. We tend to adjudicate cases between stockbrokers and investors. We also will handle some EEOC complaints, but it's something that I think could be an excellent toolbox for the elder law section.
Excellent. Okay. Well, we're gonna take that to heart and probably reach out to you to help us with that. Is that okay?
Absolutely, I'd be happy to.
I see Matthew put in here that this section sounds what I've been looking for from fiduciary section. And what's the distinction? And we may have some fiduciary law members in this group, but I'm going to give it my stab. I really think the fiduciary law section, it seems to be more kind of tax related. Is that fair to say? Higher net worth clients, I think, in some respect. So if anybody else wants to jump in here as well, at the ABA level, there's like non-tax estate and trust, and that's what we are in Valdosta, Georgia. The exemption now is 15 million if you're single and 30 million if you're married. And in South Georgia, that's a very few people fit that bill, and then that may be the same case in your communities as well. So we're not doing a ton of what I call high net worth planning. That's getting over those numbers. So we're doing asset protection training or planning and asset protection trusts that really are geared toward folks that are below the exemption amount. We're doing it to protect their assets from creditors and predators and in-laws and outlaws, as I like to say, not so much because of the tax advantage, because the exemption is so high. And now it doesn't have a sunset. Doesn't mean it can't change, right? But at least there's not a sunset on it. So we'll watch and see what happens with that. If anybody else wants to chime in on what they think the distinction is between us and fiduciary, it is a blend, right? Because elder law, you are doing wills, trust, and those types of things. And so is fiduciary law. But we tend to not have in my area here, just not many high net worth clients. And there's a good blurb, and Lane just put a nice blurb in the chat about the fiduciary law section. I think it's kind of their summary. So there is quite a blend on that. Someone mentioned an educational event that was an Emory Law, Emory Healthcare and Nursing regarding healthcare directives, end of life documents, and historical view of this and how it's changed. And that is a very, I mean, talk about really hands-on. That's great stuff. Someone said they would like to learn more about specific Medicaid planning and asset management. We are going to bring that to you in February. That is going to be part of that 6-hour CLE. Is kind of getting into some of that Medicaid asset protection. It's very common here in South Georgia for us to find someone in what we call crisis. That means we get the call and it's, hey, grandma fell, she broke her hip. She's going to have to go into rehab for her hip, but we don't think she's going to be able to return home. So she's probably going to need nursing home care, but she doesn't qualify for Medicaid because she has, the family house that, is on the farm and it's worth $350,000 and she's got 80 acres of land. What do we do? So, we can help those people. There are ways that we can help those people, even if they don't initially qualify for Medicaid. And so there's the pre-planning aspect, and then there's the crisis planning aspect. We'll dive a little bit into some of that in the presentation that's coming up as well. It says Jim Hunter in Rome also offers probate mediation program and provided his information.
Paul, I'm going to chime in real quick
Sure.
and thank you everybody for notes on CLEs. I haven't seen anything because we had a total flop at Topgolf one time. We don't want to repeat of that.
Yeah.
If folks can also chime in on if it's helpful, what kind of events they would like to see, et cetera. Paul, Josh, and I are actually scattered kind of all over Georgia. Paul is south, I'm north, Josh is kind of metro. But if people don't want to do anything, that's fine too. But just let us know on that as well in the chat.
Yeah. So is there let's see, someone put in here, add to the list special needs trust, setting up, administering, etc. Yes, absolutely. How do we set up a special needs trust? What does it do? Why is that necessary? And I see so many people that, a special needs person comes into an inheritance, right? And they're receiving some type of federal or state aid for their health care. And then they come into this money. And what does that do? Well, then they turn off the money. The federal or state money gets turned off. So then they have to put it in trust. But then when they pass away, that money has to go to the state to reimburse their care. So, if you plan ahead and do good things, we can avoid that. And it can be redirected. Someone said they're down at Jekyll Island. So virtual events are best for me. I work remotely as an elder law attorney for the Georgia Senior Legal Aid. People love the Zoom CLE as it makes it possible. We struggled with that last year. We're like, do we do some Zoom stuff? Do we do in person? I think we've only done in person. I think today might be our first Zoom presentation that we've done. So maybe a good blend of that is what everyone's looking for. Maybe we can do these. We talk about how often do we do them? Do we do them monthly? Do we do them every couple months? So chime in on that on the chat as well. How often you want to see this type of stuff. We try to do it during the lunch hour so people can grab a sandwich and eat and participate at the same time. So
Paul, I see Mercedes, said seminar mental health power of attorneys. Before everybody else got online.
You muted yourself, Bill.
Sorry, that's what a lot of people want to do to me. How this is, kind of happy law that we do, and what happens? How do you hand off a baton? The litigation baton if needed. And I think that would actually be something good to talk about. We try to do document prep. We try to do elder law planning, estate planning, but sometimes the litigation creeps in, and how do we hand that baton off somewhere so that people aren't yelling at us?
Yeah, I would be interested in that. I don't know about anybody else there in our section, but I was, when I was a baby lawyer, it was family law and criminal law and in the courtroom and fighting. And then about year 12, I said, the heck with this. So when I decided to focus the practice solely on estate planning and elder law, I said, if it smells like litigation, if it even smells like it, we're not going to take the case. And that's been our practice. So if something turns litigious, which it does on occasion, right? That is a good question. What do you do? Do you turn the whole thing over to a litigator? Recently I've been thinking, well, sometimes you get that second half of the fee on the backside. So maybe it's better to associate a litigator and stay and keep your finger in the case. But so that's a great topic for us to consider. We've got just a few more minutes before we begin our program. Someone
Hey
says,
guys,
yes, go
it's
ahead.
Paul, Bill, it's Lachey Calloway. How are you?
Oh, wonderful. How are you doing?
I'm good, I'm good. And so I saw Matt actually mention this in the chat as well. So I was gonna ask. So I know I asked you guys about this a few months ago. I did that whole memo, if you will, about pitfalls with the transfer on death deed. Did we
Yes.
come up with a listserv for me to circulate that to everyone so they can at least be aware while we're working on getting this amended?
Yes, what we've done is we've set up this Facebook group, and it's at the top of the chat is the link to it,
Okay.
and that would probably be the best place to do that.
Okay, so we're gonna use the Facebook group
Yes,
for the listserv. Okay.
yes.
Um, well, um, Garland said, please send that guide on the listserv. Which listserv are you asking about or referring to, Garland?
If they
Lachey,
would
we
set
do
one up.
not have a separate listserv other than the Facebook group. And I think internally we discussed a listserv and how difficult it would be for the three of us to monitor it, if I remember correctly. And that's why we opted for this route.
Got it. So Garland asked a question in the chat saying, please send that guide on a listserv. And so that's why I was asking, which listserv is he referring
I,
to?
I think he might have been colloquially referring to the Facebook group. We don't have a listserv for our group. We decided to
Okay.
use Facebook.
So I will put that in the Facebook group.
Yes, that would be
Okay.
fantastic. We'll get you admitted in there, Lachey.
Okay.
I know Mr. Swain also mentioned something, Veterans Aid pension benefit, and I believe he's one of the gurus in handling those things. So that's certainly something we can talk about how we help veterans, because there's a tax-free benefit for veterans and spouses who qualify. I think it's relatively tight to get that in there, but yeah, that's certainly something I think would be teed up perfectly for us as well. A lot of great comments still coming in, but I think we need to start to segue, if we could, to our presentation today. So I'm going to share that presentation as we go through this. We have an hour to get through. I think we have about 24, 25 slides. I am and Bill, I think Bill and I both feel probably the same way about this. I'm a more the merrier, and also I love a hot bench. I love questions as I'm presenting. So as we go through this, if you've got a question as we're going through these, within reason, of course, we can stop and answer those along the way. So feel free to unmute yourself and ask a question as we go through, and maybe you've run into something that would help shed other light onto these particular subjects. But with that, I'm going to bring up the presentation, and I'm going to make this big, and then I'm going to hit present. Let's see. Are y'all seeing, Lane, do I have it up the right way?
Make the same change that we made previously.
Okay, swap it. How's that?
That's
That
good.
work?
Hi, the audio on the presentation I'm trying to listen to is not working.
Can you hear me?
Right. So I thought we plugged the microphone, the speakers. No.
So if you can hear me, you've got the audio for the presentation. Because I'm going to advance the slides. Is it
Yeah,
good,
Paul,
Lane?
I think that was on the user side, not our side.
Oh, okay. I was wondering, I was like, no, it's the same audio. Okay, Bill, I'll let you take us away.
All right. Hey, everybody. Thank y'all for being here. I feel like a radio DJ. This is a little weird, so sorry about that. My name is Bill Rhodes. I'm an estate planning, tax, elder law guy out of Gainesville. I've been doing it for 15, 16 years. I am admittedly less focused on doing Medicaid asset protection trusts and things of that nature than both Paul and Josh are. So, Josh did write this presentation. I wanted to give you all kind of a heads up that I'm going to be a little broader scope in what I'm talking about. This very much is 101. So I hope I'm not talking down to anybody. I certainly don't mean to do that at all. I tell my clients I'm up here in North Georgia that I
No.
talk in small town redneck English. And if I need to switch to lawyer, I can try, but I feel like that's the best way to communicate to my clients. And please kick me, ask questions, whatever in the chat room, and I'll do my best. Some of the things that are in these slides, I think I probably disagree with to a certain little bit of quibble. I think if I had written it, Paul and Josh would disagree with it to a certain little bit of quibble, and that's okay. But just take everything with a grain of salt. I think more than anything else, it's to share ideas, prompt conversation, etc. It says everything you and your parents need to know. I kind of approached my thoughts on this as to what do my parents need to know. Personally, and I tell a lot of personal stories. My dad actually passed away about 2 months ago. And so, what do you and your parents need to know is exactly a conversation, I had with my parents several years ago, but then also had with my parents in very much a this is urgent, this is happening now kind of way. And so if I have to stop for a second, it's because I'm remembering my dad being an idiot, and I'm trying not to let that and get into my thoughts too much as I go forward. I'm going to turn the page now, Paul. If you can turn the slide. Here's what we're going to kind of sort of try to cover today, and I've got some more. Why caring for older adults is every lawyer's business. Legal documents. Everybody, not every lawyer, but everybody should have. How to spot costly elder law problems early. I'll probably bleed in some estate planning stuff too that needs to be spotted. And then, steps you can take Monday morning. I like what Josh did there. Josh does a very good job of giving people call to actions. What do you actually do next? So I appreciate him putting that in there. Why are older adults every lawyer's business? Number one, we've all got parents, whether or not we like them or not, whether or not they're still in our lives or not, but that's for most folks. My kind of cynicism comments are money and competency. Older adults carry the most wealth in the country right now. There's going to be $86 trillion transferred down from the baby boomer generation to wherever they leave it to in approximately the next 20 years. That is the largest transfer of wealth in the history of the world. And it's insane. That's just a crazy amount of money. Also, we've got to start thinking through competency of these adults, these older adults, as they do those transfers. So anybody here that's practiced for a little bit has certainly had clients, dementia and Alzheimer's are not a cliff. It's more of a roller coaster ride that's generally going downhill, but sometimes it goes really steep and sometimes it goes really shallow. And there's not a bright line test for when somebody is competent or not competent to sign off on documents. And so, I think that's part of the reason why every lawyer has to think this through, is you also got to make sure you're dealing with a competent client. If you want to Google something, just Google the Great Wealth Transfer. You know, that talks about all the assets that are being transferred when the baby boomers do retire. When we're looking at our parents, and this is something I had to look at for my parents, and I'll tell a funny story, but for years I told my parents I did not want to look at and or see their estate planning documents. They were done by a good firm in Athens. It was none of my business. And I told them that repeatedly until finally they kind of berated me to look at their wills. And we're as vanilla as it gets. 2 parents, 2 kids, same mom, same dad, everybody gets along. My dad finally brought his will, and I looked at it, and he had signed it in pencil on the back page. And I said, "Dad, where's your signed copy?" And he said, "Oh, I thought this was it." Right. And so even they had sent him a draft, he had signed it in a pencil and thrown it in his safe deposit box where it sat for the next 20 years until I finally looked at it. And so, I encourage y'all, and we'll get to this in a little bit, but I encourage y'all, if you're talking about your own parents or your clients, even if they say they've got everything in order, you got to take a look, because it's often just not, what they think they've done is not necessarily what they've done. All right, Paul, I am going to the hour-long roadmap because I've been rambling a little bit now. So I think that's, yeah. We've done some welcomes. We've done, I guess, a few, or we will do some statistics in a minute, just about the growth of the elder population in Georgia and the growth of Georgia's population generally. Then talk about the basic vanilla ways to do some planning. And then Paul will get into more asset protection documents and things like that. So I'm going to go to the next page. All right. I'm in North Georgia. North Georgia, we just had actually a high residential development freeze in all of Hall County from a zoning purpose because too many people are coming here. And so the city of Houston, which is, encompasses, several counties, also is saber rattling about a development freeze. I mean, up here in North Georgia, at least, I know South Georgia is different, but there are a lot of people moving here. There are a lot of people coming here. As Josh notes, that the 60+ population will nearly double by 2030. That's just in 5 years, right? It'll nearly double. That's incredible. What that is that's a great client base for everybody, right? I mean, it's a tremendous opportunity for everybody when we combine a doubling population with the wealth transfer that's going to happen. That's why everybody's trying to get in this space. The insurance agents, the annuity people, the financial advisors, everybody's trying to get in this space because of that opportunity that's coming down the pipe. The other thing, and this is kind of ties into the Medicaid a little bit, average nursing home bills. Nursing homes have gotten really expensive, and it's only going to go up. $8,000 a month. You're looking at it well over $100,000 a year for how do you pay for long-term care. And Paul will talk more on that later. But that's kind of the nuanced elder law side of this is how do we make sure people are cared for when they can't care for themselves? How do we also try to make sure that if they've got assets, homes, whatever that they want to leave down to their kids, grandkids, whoever, that we can try to structure things so that it all doesn't get blown through Medicaid clawbacks and or the 5-year look back period that Paul will talk about more. One of the things that I think is important to talk about too is how I think our jobs as lawyers have changed over the last 20 years. How people have held wealth in this country has changed tremendously in the last 20 to 30 years. 401ks, IRAs, brokerage accounts, all those things have skyrocketed. Small businesses having land, other items that typically have required a probate lawyer, an estate planning lawyer, an elder lawyer to deal with, is a ratio of assets, those have dropped. So we're kind of in a weird space where the assets coming through the door right now, they're going to be part of this baby boomer. A lot of them are beneficiary driven, not trust or will driven, unless we direct them that way. But I think that that does change. That changes kind of, in my view, the power balance between the advisors, between the lawyers versus the financial advisors versus the insurance agents. It changes who clients go to get advice. That's why I think in part we had the conversation earlier, or I mentioned earlier, you click on one person doing wills and trusts on a Facebook feed, and then you get 15 different ads over the next 30 days for folks. People are coming into this space because we don't control it automatically all anymore. And I think that that's one big difference. Second thing I think that we need to think about if we're advising our clients or our parents, why this matters in Georgia, is the number of, I'm going to say non-traditional, I don't even think that term makes a lot of sense anymore, estate plans. We've got lots of people who are on marriage number 2, 3, 4, 5, or whatever. We've got lots of folks who don't have children. We've got lots of folks who may be still in a same-sex relationship but have never gotten married. We've got a kick up, I think, of special needs beneficiaries. There are lots of reasons that I think that we need to think through the traditional, just leave it directly down to the kids, because that doesn't work as easily anymore. In my view, I think I've got a 16-year-old in a week. I think that there's less exposure of children and 30-year-olds these days to financial decisions than there was before. They're less prepared. And I think that that's something that matters when we're counseling and talking to our clients. The other thing that's changed too is the federal estate tax limits. Those have just gone through the roof. There aren't very many 15 millionaires out there or 30 millionaires. And, you could argue that a 10 millionaire should be thinking about it. And I think that's right. But, it doesn't apply to the millionaires anymore. And so that's been a huge difference in the need for complex estate tax planning compared to what used to be out there. All right, let's turn the page, please, Paul.
Well, there it is.
There we go. I like this. I like this distinction. Really, we've got to talk about two things at once. I think if we're competent to talk about this, and I think in terms of asset and income groupings, and maybe that's wrong, but it's how I do it. You've got people who are really, really rich who are never going to need nursing home or government sponsored, government provided nursing home care. That'll never happen for the 15 millionaires out there at all. That probably won't happen for the 3, 4, 5 millionaires out there at all. There's a break point somewhere, and I don't know where it is, right? Then you've got the, I'll say the middle class, for lack of a better word. I was meeting with a client yesterday. They've got 1.2 in retirement roughly and own a $600,000 house. But they're also really worried because both of them have family histories of dementia, and they're really worried about how they are going to pay for long-term care because their income streams are such that they're only bringing in $70,000 a year, including their RMDs right now. They don't have a whole lot coming in, certainly not enough to cover 2 long-term care stays at the same time if there's some sort of Alzheimer's dementia component to it. So that's kind of the middle group, or the people who I think that Medicaid asset protection trusts and things like that are relevant to. And then we've got candidly poor folks who may just want simple wills or something, who know that or maybe they want to just give away a house to a kid. There's lots of options out there, but the way I think through it with my clients is what are income streams and what are assets and what's at risk down the road, when candidly we can't predict long-term care down the road costs either. Let's turn the page, I guess. All right. This says 6 essential legal documents. Some of mine are all smushed together. I don't know that I would have 6 if I put this slide together. I'd also add some to it, so I don't know. I believe that what is absolutely essential is that everybody should have a healthcare power of attorney. I think that is the most important document for any of my clients, full stop. When I was recently in the hospital with my father, and I told y'all I'll tell personal stories, but hopefully examples are helpful. And he ended up, he passed away from stage 4 cancer. That's how he died. So we had 3 months of quasi awfulness to deal with. But the doctors asked, whether or not we had an advance directive, for him. You see the advance directive down here. I just called it a healthcare power of attorney. Sorry about that. That's in our office lingo. But an advance directive for healthcare that has the living will and the HIPAA all in one document. To me, having those three is crucially important, not just for the well-being of the client. I think it matters what they want. I also think it's crucially important for the family. I think that should be shared. Thoughts should be shared about how people want to die if they can't communicate for themselves. Typically, that is the most emotionally charged, physically tired, perhaps financially exhausting time of people's lives. And if the person dying, and I'm going to blame them if they haven't done it, it's not the family's fault, but if the person dying has not done that and has not laid the groundwork with their family for who's going to make those decisions, then it can be really bad. Something that surprised me is my parents always spoke about, hey, pull the plug. I call it internally the pull the plug, don't pull the plug document. But my parents always said, yeah, pull the plug on us, pull the plug on us, pull the plug on us. I mean, we didn't bring it up every time we grilled hamburgers, but it wasn't a secret. It's commonly talked about. And when my father was near death, my mom came to both me and my sister and said, hey, do you think this is what I should do? And that struck me as strange because we had talked about it, repeatedly as a family. And I don't want to go so far as to say she was kind of asking permission or forgiveness. It's hard to put a finger on it, but it just kind of struck me as odd because it's crystal clear to me what she did want. But part of the reason it's crystal clear is, number one, he had those documents, but number two, those documents and what he wanted had been talked about. And so if I'm talking to my parents, and what I say to my clients is, yeah, get this document, but the document also is not exhaustive. I had a client a long time ago who ended up passing away horribly, but his legs had to be amputated first. And his spouse came back to me and she was really angry with me. And I think I was the whipping post, and that was okay. But she said, we didn't talk about if XYZ happened, whether his legs should be amputated. And I got it, but also it's not an exhaustive document. And that's why I go back to make sure your clients are talking among themselves and their decision makers what they want and how they want to be treated in those situations. But because that is when people can be possibly at their worst. Let's go. So last will and testament, really, I think required for everybody. There's a few situations where Georgia law is the perfect default if you want to deal with some stuff. Also, is people own less real estate, things are beneficiary form driven. Last wills only cover things that typically aren't beneficiary form driven or aren't forced there through beneficiary forms. But to me, wills are vital, and I would almost always recommend them unless there's a reason not to. Revocable living trusts. I did not ever get questions about revocable living trusts 15 years ago. Now it's always part of the conversation, and I find this interesting. I think part of it is Medicaid protection trusts coming into the field because of Medicaid costs. I think part of it, at least where I practice, is we have so many people coming in from out of state where that particular state where they came from, their probate is way more difficult and expensive to get through than ours. And so I think I spend a lot of time, answering those questions. A financial power of attorney, I call that my going to Vegas document, because in theory, if you give it unlimited financial power of attorney to somebody, they can go to Vegas with everything you've got. can you sue them later? Sure. But if they don't have it because it was lost at the craps table, then you're out of luck. I think that that's the most dangerous document. Georgia power of attorney law did change several years ago to give more teeth to our financial power of attorney. I candidly don't know if the old forms fall under the new law or not. You know, somebody smarter than me or who's looked into it might know that. But I do always encourage my clients to update their financial power of attorney forms if they're still working from the ones, 10 years ago or whatever, because third parties do seem to acknowledge, respect, whatever them more. All right, if you'll turn the page, please, Paul. All right, a will versus a simple trust. I know this is a 101 class, guys, so bear with me. Most of y'all probably know all of this or a lot of it. Will goes through probate, only works after death. All that's true. I will kind of repeat what I said earlier that I don't think probate in Georgia is hard. If everybody is on the same page, if the kids or the beneficiaries are the natural heirs at law, and it is personality driven, but there's not the inventories, accountings, bonds, reports, all that stuff is waivable either in the document or by the heirs at law beneficiaries. The way I describe it to my clients is the state of Georgia isn't picking your pocket for a death tax, an inheritance tax, a wealth transfer tax. The state of Georgia doesn't have that. And I think that makes probate here easier than a lot of other states because we don't have to prove to the probate court what you're worth when you're dead. So that makes the probate process itself, in my view, a whole lot easier than a lot of other states. So, I am not a default trust person. I know there are lawyers out there that will default to revocable trust off the bat to get around the probate process. That's not my default. When a probate goes bad, though, it goes really bad, and so that's the other thing to consider. I do use something that's not on the slide called testamentary trusts all the time for often for grandchildren. We just call them grandchildren trusts here. But if an adult child dies who's going to be a beneficiary, it gets routed through the last will and testament, but a trust inside the last will and testament to a trust for the benefit of the grandchildren. And you can, like other trusts, you can put all sort of conditions, requirements, age limitations, etc. on those. So I did want to mention that. Bullet point number 2, a trust bypasses probate, works during life and after. Absolutely true. A lot of clients want to create a revocable trust while they're alive. If they ended up stepping down as a trustee, they can then have a successor trustee come in and in theory seamlessly help them take over with whatever needs to be done. I think that that's often a good idea. I also think, though, that I see a revocable trust solely for the purpose of avoiding probate fails many times. We'll get to some of the reasons it fails, but often it's because they've got after acquired assets that never end up in the trust. Nobody ever, third bullet point here, funds the trust after the fact. And whether people buy new houses, get new bank accounts, or what we see here is there's a really fancy high-end 55 plus community that you got to pay like hundreds of thousands of dollars to get into. Well, if you die in the first year, there's a kickback that goes backwards. Well, that's not in the trust. And what do we do with it? We then have to probate to figure out what to do with the $80,000 or whatever the prorated check is going back to the family. We gotta figure that out after the fact. No, I thought I heard somebody. All right, let's turn the page, please.
I was going to ask something, Bill, about when you were saying wills and trust, and how some people say the default is for a trust. Sorry, this is Lachey Calloway. So one of the reasons I'm not a default either for a will or a trust, but even though, yes, especially compared to California, we are so much easier with probate than a lot of other states. But another reason why, at least I've seen in my practice, that people are really adamant about not wanting a will is because they have blended families. And so that's so prevalent, common for us now, and they're natural beneficiaries, or natural heirs at law, I should say, versus beneficiaries. And if there's a will contest, that's where it can get tricky with blended families. And then also not even doing a testamentary trust within a will, that's still a matter of public record. And so everyone can see exactly what you left for the grandkids and every single thing with the will. Whereas with a trust, it's more private, which is why, even though we're not complicated here in Georgia and we are certainly not as expensive, there's still other reasons why people want the trust for privacy and when they're trying to take care of blended family situations. So I just
Yeah, what 100% Lachey, and I'm glad you brought up the privacy issue. You know, I rarely have clients ask about the privacy component of a will, because often what I'm seeing is 50% here, 50% there, without dollar figures being attached to it. I'm being a little simplistic about this. But if there are actual dollar figures flowing, then 100%. You reiterated something I hope I said, I thought I said about second, third, fourth marriages or whatever, because that is so common now. And that's where I see so many fights now. The place, and again, if I'm talking to my parents or step parents or whoever, the place where I see the most fights in my practice is on shared and joint ownership of real estate, involving life estates and primary residences and trusts, where nothing was really thought through. Who pays the taxes, the insurance for a new roof? What happens if the surviving spouse who doesn't outright own it wants to downsize or move into a condo in Florida? I mean, that is where I see the absolute most litigation and disagreement, but especially when the real estate is high and the kids see a bag of money there. If the old woman or old man would kick the bucket, I'm being a little facetious about this, but I trust there for sure helps spell that out a whole lot better. So thank you, Lachey, for bringing that up. On the financial power of attorney side here, Josh has linked to the statutory form. I 100% agree with Josh to add a second witness line there. I've had to argue too many times with the Edward Jones National Office in St. Louis that a notary also counts as a witness in Georgia, and they don't care, right? But adding in that second witness line makes complying with the compliance offices at these national institutions worlds easier, I think. So let's turn the page. Advanced directives and living wills. I've already talked about this. Make sure your clients are talking about this with the people making the decisions. Make sure they're talking about it with each other. I don't have anything else to say about that. All right. HIPAA releases, that's part of my healthcare document. I've smushed them all together.
Excuse me, Bill. Tom Mahoney. I don't go with living wills anymore. I exclusively go with healthcare directives, and I just was wondering, is that a common practice, or do people still see a value in living wills?
Tom, I also do not ever use living wills.
Same for me. It's in our statutory advanced healthcare directive now. It's built in there, and I think you still see a lot of the companies that are in this practice still include that HIPAA release as part of their form package and print it out. But to me, it's superfluous in Georgia. And I think our doctors and physicians and stuff are used to seeing our forms, and that's why I promote using the statutory form in Georgia for that. So that I'm in the same practice.
Okay. Paul, one more page, and then I think it's time for the baton handoff.
Okay.
So funding your plan, I'm going to start with the middle dot and then work backwards, I suppose. Second story about my father, for what it's worth, is about 5 years ago. My dad came up to me and said, "Hey, Bill, do you remember that woman I was married to in 1968?" And my parents have been married 50 some odd years at this point. And I said, "No, Dad, I was born in 78. What's up?" And that made for kind of a funny, strange, uncomfortable conversation. And he and my mom were at the VA hospital in Atlanta getting his hearing aids checked. But he decided while he was there to check and see how much life insurance he had from when he was in Vietnam. And so he checked his VA life insurance policy, and lo and behold, a woman he was married to for about 6 months, right before he got drafted into Vietnam, they divorced while he was in Vietnam, was still on that insurance beneficiary form. I see that all the time, not that exact scenario, but old, outdated beneficiary forms, whether because of divorce, whether because somebody's already passed away, whether because somebody's now got special needs or there's another child. I'm making stuff up here, but to me, that's the low-hanging fruit that if we don't have our clients look at that, we're just doing a major disservice. And I think one space that we still control in all of this is almost as a quasi disinterested party. We are not picking their pockets every single years for what their account is in their brokerage account. We typically don't have a motive to amass all their assets under our management. And so they will tell us about their other accounts that maybe they aren't telling the financial advisors about. And so I think that that's a conversation that's really important for us to have with clients. If you're going to go the revocable trust route, like Lachey was talking about, you have to get those accounts retitled. You have to get the real estate into the trust. I see so many of these things fail when people don't do that, or the trust was 20 years old and it's just outdated because they've moved from Gwinnett County to Hall County to try to get away from all the people that moved to Gwinnett County 20 years ago. They just don't redo it and don't update it. It says the last one, keep a checklist reviewed yearly. There's a book on Amazon that's like $13. I recommend to all my clients. It's called I'm Dead Now What? And it's a great non-legal book that's super inexpensive, that just creates the cookie crumbs for somebody to follow after somebody's passed away as to where to find the stuff. If they don't have that, I'll often have clients, and this is on the probate side, but pulling old tax documents and things so we can look at 1099s and figure out where assets are. So Paul, I think I overspoke for about 3 minutes, but I'm going to hand the baton off to you now, if that's okay.
Well, I
got up and left. That's not good.
No, I left because it is a great it's a great binder. Important information about my belongings, business affairs, and wishes, which is really great. And in our space too, I think it's also great. As parents age, grandparents age, to memorialize stories that they have. You can buy one of those books and then just ask them the questions and record the video and audio and all that kind of stuff. So, well, great, Bill. Thank you so much. All that is very informative, and everything. So we're going to, if I can make my computer work, go through a quick issue spotting checklist here. As people change, or age, we want to be able to assist those folks as they go through that. And I think that in our space as elder law attorneys, particularly if you're doing trust-based planning, is making sure, instead of giving them a will, instead of giving them a revocable trust or an irrevocable trust, we know they're all flavors of different types of trust that are out there. You want to be able to help them go through that and stay on top of those things. How many times has someone brought to you a will or a trust that was last looked at 10, 15 years ago? How many times has someone brought in a trust-based plan that was never funded because they put it on the shelf and they don't do anything with it. So I'm a big advocate of education and maintenance plans for our clients.
Can I
Um,
interject on that point? I know you said you like a hot bench.
I do like a hot bench. Come on.
So I do the majority of my legal practice is real estate.
Oh, good.
And so what I'd like for the trust attorneys to tell their clients is that you do have to show the real estate attorneys the trust if you are selling the property. We get
Okay.
pushback on that all the time, that my attorney told me I didn't have to show the trust to anybody.
Ah,
Well, we're transferring title to the real estate that you actually did fund and put in your trust.
yeah.
Yay, because I see the opposite happen as well when they don't. But they put the property in the trust. Now they're selling, they're downsizing, they're moving to follow the grandkids. And we have to have that trust document. We have to have the powers and authorities. We have to have all the amendments that they've made
Absolutely.
over time. And we are constantly told, my attorney
have
said
to
I
show you
didn't have to, I don't have to show you
Yeah.
that.
Yeah.
Yes.
And,
So
and
that would just be my tidbit of please help us.
I appreciate that. And when we go through and do our review and sign of a trust, we have the trust document, which in our office is typically 70 to 100 pages. And with that document, we have a certificate of trust, which I believe, as a real estate practitioner, you probably file that certificate of trust with the deed, do you not? Do you do that?
In my area, we do not. Some attorneys do, but our
Okay.
title insurance company requires that certificate of trust to be
Right.
dated within 2 years of
Oh,
the
okay.
transfer.
Yeah.
And we still have to see the trust. Even if we use the certificate of trust, we document that in our file.
Interesting.
But they still require us to see the trust, and they require us to that certificate has to be dated within 2 years of the transaction.
Oh, okay. Well, those are some interesting things that I had not heard about before, but are good to know from this standpoint. So I appreciate you speaking up and talking about, from the real estate perspective, this is what we do. I'm a reformed real estate attorney myself, so did a number of those.
Totally get it.
My mom was a title abstractor for 20 years, so she
Right.
told me everything she knew. So that's interesting because when I do it, I say, look, this is your trust document. A lot of people don't like to share this with their local bank or whatnot. And here's a certificate of trust where we can attach relevant pages from the trust. So of course, if a client were to come to me and said, we can't do this real estate transaction without, providing them a copy of the trust, I'm like, okay, well, you either are going to have to give it to them, or if they won't accept relevant pages, we'll have to work through that on a case by case basis. But it's good to know that there are some title companies that are requiring that and what are requirements of their particular to close the transaction. And also the fact that, because we can do an updated certificate of trust, anytime. So if 2 years has lapsed, it's not very difficult for us to generate a new one to satisfy that requirement. So thank you for offering that. So, we're talking about, the education and maintenance program, so we can, constantly be available to help clients in doing that. But anyway, we're as people age, how is care going to be paid for? I say there's 3 ways, right? If they have a long-term care insurance policy, and those aren't as good as they used to be, right? The insurance companies figured out how expensive it was going to be, so now the premiums are through the roof. You can have a long-term insurance care policy, but it may only cover a portion. You can privately pay to the tune of $8,000 to $12,000 a month for nursing home care, or we can use a program called Medicaid, which is a joint federal state program, but there are tight restrictions. And they say Medicaid out there is for poor people. But when they were doing all this debate in Congress recently, talking about Medicaid and cuts to Medicaid and whatnot, the congressperson said, Medicaid is not a program for poor people alone. It is also a program for people that will quickly become poor if they need long-term care. And y'all, at $10,000 a pop, and you're only bringing in $1,500 100, 2,000 in Social Security, and maybe there's not another safety net. Maybe they're not an IRA millionaire. You can see how that's going to deplete their funds very quickly. So, also as people age, we want to make sure who has legal authority. How many of you have gotten a phone call that says, Grandma has dementia, I need a power of attorney, or I need a healthcare directive? Well, how far is her dementia gone? Are we in the early stages? Does she know who her people are, and does she know what her assets are? And oh no, she doesn't have a clue. Well, we can't help those people, can we? Now we're in a guardianship and conservatorship situation. We've got to go to ask the court for permission. And where will the person live, and how will they live? So those are some issue spotting things that we have to tackle when people come in to see us. So getting ahead of crisis. In our firm, I say we have two types of people. We have those that plan ahead, and we have those people that are in crisis. And earlier I mentioned the story of Grandma broke her hip and whatnot. Those are the people in crisis because they've done nothing to plan ahead. And when we don't plan ahead, we can't protect as much. If we can get ahead of that 5-year curve that Medicaid has in place, they look and see if you've made any transfers 5 years before you need care. But if we can do that before they need care, so then the question is, well, when should I do this? I'm like, I don't know. I don't have a crystal ball. When are you going to need nursing home care? So we don't know these things. So you plan ahead. Mention here about starting conversations early, and I'm a big advocate of that. And we're on the it's Halloween's coming up here in October, and it's going to be Thanksgiving and Christmas. I always talk about the Thanksgiving and Christmas conversations because some of you probably get really busy about that time or right after Christmas. Hey, we went home for Christmas to have Christmas dinner, and we noticed mom and dad or mom's slipping and she's not remembering stuff. So having conversations, knowing what your folks and what your loved ones want is important, and it's important to have those conversations. And updating our documents. This says every 3 to 5 years. I think that's a pretty accurate thing. There are certain things that trigger this, right? There are certain things, and I always say I tell people, things are going to change in your life, the laws are going to change, and we're going to learn new strategies to continue to protect our clients. And then reviewing long-term care insurance policies and what they will cover. So Medicaid will help with nursing home bills if the eligibility rules are met. So those that are in this field and do this Medicaid asset protection stuff, and I don't know what percentage of y'all do that, but basically, if you're a married couple in Georgia, and different rules have different states and what they count as qualified assets and non-qualified assets for inclusion in this formula varies. But for the most part in Georgia, if you're a married couple, you can have a house valued up to $600,000 or $700,000. I think it's up to $700,000. Now you can have a house, a car, and up to approximately, I think it's $157,000. And anything over that, you would not qualify. IRAs are considered exempt, if you will. The RMDs that you're receiving from them are not exempt, but the IRA asset itself is considered exempt if you're in a periodic distribution status, which means you're taking the RMD. So sometimes you'll trigger them to protect that IRA. So if you're single or widowed or divorced, the options drop dramatically because then you can only have a house and a car and $2,000. And if you have anything over that, you're not going to qualify for Medicaid. So, how do you go about qualifying for Medicaid? And a lot of times we use a Medicaid Asset Protection Trust where we move it into trust, hopefully 5 years before you need care. Because if you do that, then you don't have to disclose it because the 5 years, you only have to disclose the items that you've moved into trust in the previous 5 years. So those rules are tricky if you're not doing them and applying them and looking at the formulas that the government uses. And we're going to do a deeper dive on this particular issue when we do that workshop in February, the CLE in February. I often tell people because people will say that I don't want a government nursing home. And I whisper, they're all government nursing homes because they are all receiving Medicaid, right? And I tell them, I was like, guess what the difference is between a Medicaid paid for room and a private paid room at any nursing home in America? Nothing. There's not a difference. And I also tell them, like, there's good nursing homes and bad nursing homes, right? And we typically, if we're in this space, we know which ones are good and which ones are not so good. So I tell people not to get wrapped around the axle about that. Veteran, I know Mr. Swain was on here earlier. I don't know if he's still on. Veteran aid and attendance adds tax-free income for wartime veterans. That is a very niche area what it applies to, and you have to have served in certain wartime. But it's a pretty broad category of people, and it does provide a very good tax-free income for those veterans and spouses if they meet certain conditions. They have to not be able to meet certain activities of daily living, and they have asset limits. I think they're a little tighter than they are. And they used to not have a look back period, but I believe they imposed a 3-year look back period several years ago, which I think has made those a little more difficult to achieve for some people. But I welcome any thoughts from Mr. Swain on that, as I know he is kind of the guru in the state. So legal tools like trust and caregiver contracts can protect savings. So there are things that we can do to help people protect their assets. Using powers of attorneys and trusts are important to help folks as they age. If you don't have those, and the person has gone too far and they haven't executed a power of attorney or a healthcare directive, then what are we going to have to do? We're going to have to go to the court and get the authority to take care of them. And anybody that's gone through guardianship and conservatorship actions, you know what's involved, and it is not easy to do. So it's much better to get ahead of that. And I always tell people, when you turn 18, I sent my son this past fall up to the University of Georgia. He turned 18, and he left here with those documents in place, right? Because and now he's an adult. So I can't just get access to his stuff unless he says it's okay. So, made sure those documents were in place. And I argue that anybody who's 18 should have a advanced healthcare directive, the Georgia statutory power of attorney, and a will. Those are the building blocks. And that's and y'all know 40% of Americans do not have any of those documents. 40%. So there's a lot of people, there's a lot of folks that we could help. But of course, you can't make a horse drink water, right? So, and y'all jump in if you have any questions here. Talking about the long-term care contracts, I think Josh really has a lot more experience, frankly, with these long-term care contracts and reviewing them. We do review them on occasion. This is diving into the admissions papers, talking about the responsible. Really read what you're looking at. Particularly if your client's the assisting party, you don't want them to be on the hook for the care when they do this. Read the arbitration and refund clauses carefully, negotiate before signing, and make sure the changes are in writing when doing those. So I think one of the best ways to talk through these things is to share stories. In this one, we have a hypothetical dad who's 72, has early dementia, and mom is healthy. The house is worth $350,000, and they have $100,000 in savings. And dad needs adult daycare now and nursing care later. So how do we protect them? And when I was talking about the house, you can have the house, you can keep the house and still qualify. Yeah, but what does Georgia have now? They have Georgia Estate Recovery Office. I was not far into the practice of my law when someone brought me a letter from the Georgia Estate Recovery Office, when the federal government started leaning on the states to enforce that provision in the law. So Georgia was forced to have to go after property that is left. And so typically, in this case, if dad needs nursing home care, and mom's healthy, mom will be able to continue to live in the house, right? But when mom dies, what's Georgia going to do? They're going to go back and they're going to say, hey, you owe us X amount of dollars. You owe us, say, $200,000 for dad's care while he was in the nursing home. They have to sell the house and pay back whatever they received. So it's while they would qualify for Medicaid with that home, at some point, you're going to have to pay the piper, if you will. So it doesn't always protect it. And a lot of people in my neck of the woods, the house or the family farm is the main thing that they have to pass along as their inheritance. So, you know, we hear a lot, there's a lot of IRA millionaires. Even in South Georgia, there are a lot of IRA millionaires, but and then there are some people that just have, you know, a very nice, you know, home. A $350,000, $400,000 home is a very nice home in South Georgia, and that's the main asset that they want to pass to their loved ones. So they're not going to be able to do that if they haven't planned ahead. So what should the Smiths do in this situation? Well, of course, make sure advance directives and powers of attorney are in place. Set up a Medicaid asset protection trust to protect the house. You know, and I always say you have to do that 60 months in advance, but you can start getting some benefit even before 60 months in some cases. So protection, and that varies on each individual person. Look at income for future care costs. You know, what are they going to have coming in Social Security wise? Are they going to have RMDs coming in from their IRAs? Are they going to have, do they have a pension? You know, the pensions are still, we still see those. I think it's going to become fewer and fewer as the baby boomer generation transfers their wealth. We're going to see less and less pension money, more of it in the form of IRAs and 401ks. And then making sure that that the caregivers know where the documents are, right? We put all of our trusts and estate planning documents typically in red binders, and we tell the family members, look for the red binder and bring it in. We'll go through it with you. Then we have Miss Johnson, who is 85, is a stroke survivor, no children. She has a bank account of $60,000 in a small condo. So, you know, she's single, so she can have only $2,000. And she's got 60, so she's $58,000 over the limit for Medicaid. And she's got a condo. The hospital wants a court guardianship. So if there's no documents, then you will have to get, if there's nobody that can handle her affairs, of course, you will have to do guardianship, conservatorship. The Medicaid application will have to be filed. There'll have to be a spend down plan. So she'd have to, if she hasn't done prior planning, she'd have to spend down that $58,000 over. A lot of things that would have to be done in order to get Miss Johnson taken care of if she didn't plan ahead. Some ethical considerations for us to consider: clarify who your client is when the family attends. Who is your client? If your client is the elderly person, you got to make sure that you're respecting and keeping confidence. I know a lot of my older folks bring their daughter, son, their trusted person with them. And documenting, you know, is it okay for me to talk to this person? Are you giving me permission to do that? Documenting that permission, getting them to sign off on it. Telling your folks to watch for diminished capacity signs. That's why, particularly at the holidays, I'm telling people, hey, when you go home for Thanksgiving dinner, make sure you're checking your folks out. Make sure you're checking grandpa and granny out, making sure that, you know, are they doing okay? How's their mind? Reporting elder abuse when required by law, but also making sure that confidentiality. I'm like a hawk when people come in, the people come in, particularly without the elderly person at issue. I'm like a hawk because there are some people that are preying on older folks. They're more interested in getting their money and getting control of their money. I know somebody got control of an account and went out and bought a beautiful $60,000 pickup truck with grandma's money, and I think got arrested for doing so. Did not become a client of mine, but I was meeting with them, and this all kind of fell apart. And but I'm like a hawk on that, and I encourage you all to be too, to make sure that people are not taking advantage. If you're not comfortable with it, say no. And I've done that before with existing clients. And I kick everybody out of the room, and I'll talk to the individual. And you know what answer they give me about what they want to do? It's the last person that got to them. They just parrot what the last person, and you bring them in the next day and they'll tell you something completely different. So if you're not comfortable and you don't think they understand what they're doing, then don't do it. It's my recommendation. So this is a Monday morning checklist. Download and have folks do the powers of attorney. hold a 15-minute family meeting this week, review beneficiary. This is huge. I think whether you're doing a trust-based plan or will-based plan is looking at those beneficiary designations, because beneficiary designations trump whatever is in a will or a trust all day long. So you're going to have, if you want to make sure the result is exactly what the client wants, you've got to be looking at those beneficiary designations to make sure that everything is going exactly where they want it to do. Questions. We have about 4 minutes before we need to conclude. So I wanted to open it up to any questions and comments here at the end. And we have, how many people are still on with us?
Paul, I got a question, I guess, to maybe kind of sort of kick it off. This is for everybody because I don't know an answer. How do you keep that kid from attorney shopping that parent?
I don't know that you can, right?
I don't think so. That's why I'm just
I mean,
asking.
I think it's, you know, the attorney kind of being able to peel back the onion and listening for those things. Sometimes they'll tell you, we went to this lawyer and they wouldn't do this for us. I'm like, well, that's a flag. but do they always volunteer that? No, they don't. I think that we're not medically trained, but we do this so much that it's kind of a sense, right? Anybody else have anything they want to comment on that? How do you keep somebody from attorney shopping a parent or loved one?
Mercedes Merle here. I was going to say you can't really maybe prevent that, but I see and I find it, you know, when I'm in court kind of guardianship, conservatorship, I have attorneys using the information they used when the proposed ward came in as theoretically their client, and it became clear that along the way the person, their client, became incapacitated, and they tell their family, oh, you need a guardian now because I don't think the client's incapacitated anymore, has capacity, to sign any documents, and they show up in court representing the children in an action for guardianship against their parent, and that's a big conflict of interest because, you know, in those attorneys, if you can find out any of those attorney shopping things, there's conflicts out there also, you know, that they can't then use that information to come to court. And I'll give you an example. I was in one not recently where the attorney was representing the children, and the ward kept saying to the judge, I was another party in the case, but the ward kept saying to the judge, I paid that attorney and he was my attorney previously. And the attorney stood there and said, no. But then he turned around and told the judge, she didn't pay me any money, but she came to my office with the family and pulled a landline out of her pocketbook and tried to call family members with that phone. And I'm like, now you're testifying against, you know, so you have to watch for those, because that line, a lot of attorneys don't see any distinction in that when you move from, you know, the document phase to maybe perhaps a trial kind of phase.
You're absolutely right. You're absolutely right. And we want to make sure, we have to be very careful because we want to make sure that people have autonomy, as much autonomy as they can, as long as they can. And they're typically our client, not the kids.
Right.
And that's in my engagement letter. I encourage you to put it in yours too, that your kids are not my client. You are my client, and I'm going to be looking out for your interest. You know, so yeah, I think that's very important to keep that distinction. I think we have time for just one more question, if anybody has one.
Yes, this is Virginia Wadsworth. I have a question about the HIPAA release. Is there a standard in Georgia? Is there a standard HIPAA release form that you use? And I ask the question because I've encountered situations where I've presented a HIPAA release form to a hospital or to a doctor, and they say you have to, you know, complete the HIPAA release form that the hospital has. And so I just wondered, you know, whether you had come across that, and is there a standard form, you know, that's generally acceptable?
I would argue that the one that is part of the statutory Georgia Advanced Healthcare Directive is this, it would be the most recognized standard form possible. I don't know if the hospital can require you to use their form. I do know that we put some teeth in the statutory form power of attorney. Now that's not the healthcare one, that said that they had to accept that statutory form, but they couldn't pull this, hey, you got to use our form business, because a lot of banks and financial institutions were doing that. With respect to the HIPAA, that's a good question. I will delve into it, but I do not know of a standard HIPAA form. If anybody else does, chime in. But I would argue to them, hey, this is by Georgia code, this is an acceptable HIPAA release inside of that document.
Okay.
So that's how. Anybody else want to add anything on that? I see our time is up. I want to be respectful of your time and let you all get back to your day. Thank you. This was, I know it was very informative for me. I hope it was useful for you all. Keep giving us information. Join that Facebook group. And thank you all again for joining us today.